Now let's get started. We are honored to have lead these discussions licensed attorney and professional fiduciary Darby Jones, a member of the Florida and Maryland Bar. Darby serves on the executive council of the Real Property Probate Trust Law section of the Florida Bar and is a registered professional guardian. Darby is also the founder and executive director of the Professional Fiduciary Council of Florida. Today, we're diving into estate planning, including the 10 things you should know before meeting with an attorney. Darby, what do we need to know and where can we go to find resources to help us on our estate planning journey?
Well, hang on, folks, and I hope y'all have a piece of paper in front of you and something to write with, because we are going to cover a lot of really good information for you today. And keep in mind that these episodes, if you miss it or if you want to listen to it again, they're all archived on a YouTube channel called Aging Academy. Aging Academy on YouTube. You can go back and watch all the episodes from the very beginning. And I'm going to make reference to a couple of episodes today that are relevant subjects that are very tied into what we're going to discuss today as well. So one of the things that Michelle and the AARP and I want to do is make sure that our time together is really thought-provoking and important, that we're not wasting your time and that we're giving you meaningful, practical, true, real education. This isn't a sales pitch. This isn't any kind of a classroom setting. This is going to be real talk. Your comments in the chat are really important, and we're happy to entertain those questions throughout the event. You know, Michelle and Chandra will try to manage any questions that you might have. I also want to take a minute and also thank the AARP of Florida for actually coming up with this idea and giving me the opportunity as president and executive director of the Professional Fiduciary Council of Florida to be here. So thank you, AARP. Appreciate it. So estate planning. Wow, what an exciting subject. I'm sure everybody is just thrilled with the idea of having to call an attorney. Nobody likes to do that, sadly. But in this instance, it's very important. Getting your affairs in order, you hear that all the time. A big part of that is estate planning. So you're going to need today, I hope, to walk away with the feeling of confidence and more comfortable about getting your affairs in order and engaging an attorney and why and how. So you don't want your life while you're still alive to become stressful or at risk. So getting your affairs in order isn't just about who gets your stuff at your death. In fact, more importantly, it's from today to the date of your death. That is the most important time of your life, and which should matter more than who gets the car at the end of the day. So try to focus on you and yourself when you're doing your estate planning. We're going to walk through 10 concepts. There's a lot to cover, so I may not be able to address every single question or any nuances that each of your states might have. So keep in mind that every state is a little different with the way they do probate or handle estate administration. So what I'm going to present today is really a more general overview, which I think you'll find very helpful. But keep in mind, I am not here as a lawyer. I am not giving legal advice. I'm just sharing with you my experiences and my insights that I've had for the last 20 plus years. And hopefully it'll give you some insights and ways to feel comfortable and understand estate planning. So first up is, do not let the hourly rate or the fear of the cost of an estate plan have an impact on whether you do or don't want to get it done. Don't be focused on the hourly rate of the attorney when you're in that office. Don't be nervous or quick about your meeting because you're so worried. You know, you're imagining this clock and this, you know, whatever, $400, $500, $600, $700, $800 an hour attorney. Try not to let that drive your estate planning meeting. You need to view your meeting with the attorney as a consultation. This isn't about buying a product. It's not about buying a bunch of forms, even though, we all joke about how it's just some, legalese form. They, fill in the blank and that's all they're doing. Why do I have to pay them so much? So try to keep this as a consult and use it as an education for what you are really doing. Don't let them talk past you or over you. Feel free to stop and say, help me understand what that document is and why I need it and what are the repercussions of it. So again, part of that is not worrying about the cost. Okay, a professional is going to cost money. It's just that simple. Everybody, there's probably a lot of you out there that have probably spent a lot more time worrying about how to plan a wedding or how to buy a car than you have in focusing on your own estate planning. So try to keep that in perspective and not get caught up on the expense of it, because it's your life and it's your family's life that you are planning. So yes, it's going to cost some money, unfortunately. Now, also, there are legal aid societies throughout the country. There are legal services offices that may be able to help those of you that can't afford a private lawyer, but they are out there as well. So make sure you take advantage of any source that you have other than the forums on the internet. Okay, that would be the last place to go. Also understand is, I'm sure if I asked this question, many of you would raise your hand. There is no such thing as a simple estate. Okay, so when you call the lawyer and say, oh, I just have a simple estate, just need a little will, there is no such thing. I've never seen one. I've never been involved in one. So estate planning can get complicated very quickly. A lot of attorneys think they can do a will, but not every attorney can do a will. And for that reason, estate planning can get very complicated very fast. For example, okay, pretend you're all in law school right now in your estate planning course, and you're reviewing a will that was handwritten by a lawyer. This is a true story, long time ago, because lawyers think they know better, of course. They're writing their own will, and it says, I want my estate divided between my wife and my 2 children. Signed so-and-so. Signed Mr. Know-it-all. Okay, so too bad we don't have a poll question for this. Would be a good one. But how many of you out there think that that means 50% to my wife and 50% to my 2 sons? Probably a lot of you. How many of you think that it meant 1/3 to my wife and 1/3 to each son? So I see Jennifer out there raising her hand. So here's the problem. Because there was a lot of money at stake, which is another thing, like why didn't the guy go to a lawyer to get this drafted? But something as simple as a comma would have solved that confusion. But hundreds of thousands of dollars were spent litigating that sentence. Now, obviously, the mother was not the mother of these children. It was a stepchildren situation, which is, again, something that oh, Michelle thinks half goes to the wife and 1/4 to each child. So, okay, there's another side of the lawsuit. Good. So, but something that simple can cost your family an expense downstream, which is why I encourage you to go to a lawyer, get qualified documents in place. Don't try to do these online or fill in the blank forms. And also, please don't get your estate planning advice, as much as it's thrown at you from every direction. Don't get your estate planning advice from insurance people or people in a bank, okay, trying to sell you products. They are trained to be able to talk about estate planning, but they're not estate planning attorneys. So as tempting as it is to have your financial advisor give you estate planning advice, or the advisor in the bank branch lobby or the teller in the teller line, do not take estate planning advice from those individuals, please. Number 2, how to select an attorney. you know, how attorneys in many, many states, their advertising is very limited. They're not really able to advertise like you do regular businesses. You don't, seems like the only ones that can advertise in Florida are the personal injury ones. I'm not sure how they got around that, but in any case, you don't see a lot of estate planning attorneys advertising because they're very strict on those regulations. So how do you pick an estate planning attorney? Well, first of all, if you have decent friends, which I'm sure all of you do, referrals from friends is a great start. Talk to your friends and see who they have used and whether they're satisfied. Look at your local bar association. There are bar associations in every state and every community. And if you call the bar association and say, hey, can you tell me or send me or go to the website and see who are the attorneys who are members that do estate planning. You can also look at estate planning councils. There are estate planning councils across the country. There's a National Association of Estate Planning Councils. I think the resources in the chat, maybe we'll have it drop in here in a minute. It'll also be on the follow-up email from Michelle and the AARP with that resource as well, the National Association of Estate Planning Councils. There's also ACTEC, A-C-T-E-C. That's the American College of Trust and Estate Counsel. That's kind of a fairly elite group. So if you go to the ACTEC website, you can then drill down and find out what attorneys in your community are actually members of ACTEC. It's a pretty substantial hurdle to get into that association. Then you also have NALA, which is NAELA. That's a National Association of Elder Law Attorneys. And we're going to talk a minute about the difference between estate planning and elder law, which I think is very important. And then also you want to look at their websites. Okay, everybody can have a website. Okay, anybody can be anything on the internet. I think hopefully you all have learned that by now. So when you pull up their website and it says, you know, Susie Smith, attorney, and she does bankruptcy, she does real estate, she does family law, she does corporate law and estate planning. Don't go to her, okay? You want to find an attorney that just does estate planning. And hopefully they also are board certified estate planning attorneys. And you also want to look and see, when did they graduate from law school? If it was last year, I would not go to that attorney either. You, just like when you're getting on a plane, that pilot, I always look to see if there's some gray hair on that guy, because that's the plane I want to get on. So you want to find an attorney who's been doing estate planning for a while, because there is a lot, gosh, I know so much more today than I did 15 years ago, just by being in and around estate planning. And these are just simple tricks and tools that you don't learn in law school, sadly. So experience matters. And just to touch on the difference between an elder law and estate planning attorney, just because you're elder doesn't mean you go to an elder law attorney. There's a lot of kind of confusion about the difference. Elder law really came to being fairly recently in the universal scheme of things, in the land of law. It's a pretty new service. And it primarily was developed to deal with disabilities and benefit planning. So for example, Medicaid, Medicare, Medicaid, which is you are impoverished, you have no assets, so that the government is going to come in and pay for your care, and how to apply for Medicaid benefits for many people is very important, but it certainly isn't for everybody, clearly. So that's what elder law's focus truly is benefit and disability planning. They also, many of them do estate planning as well. And estate planners sometimes delve into as elder law. But my recommendation is, for those of you that are looking for estate planning, go to an estate planning attorney. For those of you that may really need some Medicaid or benefit planning, whether it's VA benefits or so forth, go to an elder law attorney. Now, don't be bashful. Let's say you hang up today and you're ready to get motivated and get your plan updated or get it done, and you're making those calls. Don't be bashful about asking how much it costs. And don't be bashful about saying, am I the right client for you? You know, have an idea of what you're worth, what your situation is. So when you're on the phone with them, you know, you don't need to be buying a Cadillac if all you really need is a minivan. Okay. So you want to make sure you're in the right firm, that you fit their client base so that you're not disappointed and they aren't, it's not a disconnect. Also don't fall prey to the clickbait that's out there. It's been out there for a long time. The avoidance of probate. Okay. Oh my gosh, you've got to come into my firm. I'm going to help you protect those assets and we're going to avoid probate. And really, it's about your estate planning. It's not about avoiding probate. It's not about protecting assets so much. It's your estate plan. Now, today, there is some new clickbait coming out, finally, to get us off the avoiding probate train. And it's called incapacity planning, which I'm okay with that clickbait. That's kind of okay, because that's really what estate planning is, frankly. Because incapacity planning really is a power of attorney, healthcare surrogate, and a living will, which is exactly what estate planning is. So if you hear incapacity planning, that's okay. If you hear that their big claim to fame is avoidance of probate or asset protection and stuff like that, that's probably not okay. Okay. Not that it's bad, it's just it's more slick than it needs to be. Number 3, know what you own and how it's titled. So it's important to be familiar with your stuff. Okay. What accounts do you have? What's their value? Are they taxable? Are they not? Do you have real estate in other jurisdictions? Do you have closely held corporations? Are you a beneficiary of a trust? Do you have partnerships? Do you have any assets that matter or of value? Have an idea of what that is, what they all are, and how they're titled. Also have an idea of what your income is, what your tax bracket is, so that when you're calling that attorney and you're saying, you know, I just want to make sure I'm in the right office, I'm a good fit, this is kind of our net worth, this is where we are. You know, we have a closely held corporation, we've got a disabled child, we have other issues. Put that in front of while you're calling so that they know who you are and that you're a good fit. And clearly, when you meet with the attorney, you want to have all that written down. Not necessarily in I'm sure some of you have it in an Excel spreadsheet, but it doesn't need to be. You can just have it in a list of the things that you want to be able to say to the attorney when you're meeting with them, the values, how they're titled, etc. Very often, they're going to send you an estate planning questionnaire anyway to probably complete before your meeting, which is very good. And it'll force you to go through sort of your own assets and take an inventory of what you have and how it's titled, which is very important. And take that very seriously. Now I'm going to talk a little bit about how things are titled and how some people try to kind of do it themselves. Kind of like DIY estate planning, which none of you today are going to do that. Okay, because you're going to know better after today. So, for example, you know, let's say Michelle and Chandra and Jennifer are my 3 daughters. Okay, Jennifer Poor, I hope you don't mind. And so I'm doing my estate planning, and I have an annuity. I own my home, and I have a big fat CD. And I think, oh, I'm going to avoid probate. And I know what I'm going to do. I'm going to put Michelle as the beneficiary of my CD. So it just goes to her directly. And that's called POD or TOD, pay on death or transfer on death, POD or TOD. So I know I can just put POD on there and it's going to go to Michelle directly. And we don't have to worry about probate. And Chandra, I'm just going to do a deed so that she gets my house directly at my death. So we don't have to go through probate. And Jennifer, I'm going to put her as the beneficiary of my annuity. So she's going to get the annuity at my death. Now, some of you out there probably think that's a great plan and we avoid probate, no problem. It's the awful plan. It's horrible. Let me tell you why. Number one, Michelle is the winner here. Actually, Chandra is. Chandra gets my house at a stepped up basis. So let's say I paid $1 for my house, and she's going to now inherit the house at my date of death value, which could be $10 or a lot more than that. So she's going to inherit the house at my date of death value. So there's all that capital gains is gone. She can turn around and sell that house for the $1 million that it's worth. No taxes, total win for her. Michelle is going to inherit my CD immediately. And in Florida, no taxes. We don't have estate taxes in Florida. Don't tell anybody though. We got enough people here. But so Michelle is going to inherit my CD. Easy peasy. Poor Jennifer, sorry, is going to inherit my annuity. Now, I'm not a fan of annuities. We're going to have next month, we're going to have an episode about financial products and what to watch out for, but annuities are not an investment of choice. And the problem is you hear the guaranteed income and the tax-free and everybody thinks that's wonderful. But the problem is when Jennifer inherits that annuity, all those deferred taxes come due. So she's going to have to pay all the taxes that I didn't pay during my lifetime. So she's the one that is going to be very unhappy and not treated fairly. And she was my favorite daughter too. So what a shame that ended up being. But that's a very common DIY estate planning. And that's the kind of advice you get when you're in the bank. Oh yeah, just put your daughter as pay on death and you don't have to worry about probate and it's so easy. No, it's not. And you don't want to put your daughter on your account either as a joint owner because, oh, my daughter's up in Indiana. I live in Florida. It's so much easier for her to be able to pay my bills, blah, blah, blah. But the problem is, what if your daughter gets in an accident and runs over a 30-year-old with 3 kids? Your account that she's titled on is going to go into that lawsuit. Or let's say your daughter has a gambling debt or your daughter goes through a divorce. All of your assets, now that you're jointly titled, are going to be involved in all of that mess. So don't put anybody as a joint owner of any bank accounts unless it's your spouse, period. If you don't remember anything else today, remember that. And the way that your daughter in Indiana can write checks is what we call a power of attorney, which again, you're going to hear more about that. And it's one of the most important documents out there. Okay, number 4, be ready to communicate your goals with the attorney. And I mean, communicate. Don't be intimidated, okay? I made it through law school. Anybody can make it through law school. So don't be intimidated by the attorney. Don't let them do all the talking. You're there. You need education. You want to understand what the process is and what you're walking away with. And you need to be there with that information I told you about, your finances, the titling, what you own, what you don't own. But even more importantly, you need to talk about your drug addicted children or your ne'er-do-well son or the spouse that's maybe entering some dementia issues. You need to talk about those hard conversations about your life and some of the dirty laundry, any illegitimate children, any drugs or bad kids, good kids, illegitimate kids, whatever you've got, you need to be able to share that with the attorney because your plan is going to need to address some of those issues. Blended families, it's tough. I think a lot of blended families are reluctant to go to an estate planning attorney because they have not themselves had those hard conversations. I don't want my husband's mother or my husband's mother taking care of my kids from a different marriage. Who's going to be the guardian if I get run over by a bus or down here eaten by a shark or blown away with a hurricane, whatever disaster there is. So blended families have a unique kind of situation and a little more tough conversations about who gets what. And the problem is if they don't get their plan done, it's just you're all banking on who lives the longest, wins. And that's no way to, Thanksgiving is very awkward when you don't have your plan put together. So, and don't bring your family with you to the estate planning conference. Okay. It should just be you or just you and your spouse, not your kids, not your caregiver, not your neighbor, friend, just you. Number 5, we're already almost halfway through here and we've got a lot to cover. So I apologize if I go too quickly on this next section. This next section is super important. But you'll have to keep tuning in because we can review some of these in more detail in future episodes if you want me to. So in your comments, let me know. But the next section is the documents. Okay. There are typically 5 documents. You're going to have a will. You're going to have a power of attorney. You're going to have a healthcare surrogate. You're going to have a living will and maybe a trust. Okay. In the decades that I've been doing this work as a professional fiduciary and as a trust officer and as an attorney, I hate to say this, but most clients that I work with that have trusts really don't need them. It's been a very heavily marketed tool for people, but you really often don't need them. And we're going to talk a little bit about that in a minute. Also keep in mind, and Shonda reminded me of this before we got on the air today, that children need an estate plan as well. So just because we're getting older and we feel like we're all going to die tomorrow and we need to get our estate planning done, don't forget that we have children. You've got a 20-year-old that's off at college. They need to have a power of attorney and a healthcare surrogate in place as well. If something were to happen to them, who's going to speak on their behalf? So once someone's over 18, anyone really does need to have an estate plan in place. Okay, so the will. Basically, I think most people out there know what the will is. It is the document that disposes of your assets, and it also requires court supervision, which is a good thing. And that's what probate is. And we're going to have a little probate show here coming up in a minute. I'm not going to go any further into a will because I think you all really understand what that is. It is a deposition, it's a disposition of your assets to whoever it is you want to have it. There's an executor or personal representative appointed, which is a very important role. Then you're going to have a power of attorney. Again, you've heard me say this several times. That to me is the most important document that you could possibly have in your possession. That is why you're going to avoid a guardianship. If you have a solid power of attorney in place, you don't ever have to worry about being in a guardianship. Okay. And that's why a lot of guardianships end up happening because either they don't have a power of attorney or the person they named in the power of attorney to act on their behalf, called the agent, was an idiot and they should never have named that person. Okay. So you need to have a power of attorney, but then you also need to be naming the right person in that power of attorney in all these roles as executor of your will, as agent in your power of attorney, as your healthcare surrogate, as well as your trustee, if you have one. So naming a fiduciary is super important. And I'm going to refer back to our very first episode about what is a fiduciary. So if you want to hear more about fiduciary, what is the duty? When does it come into play? How to pick? You go back to episode 1 and we talk about that in great detail. Then so the living will. Okay, living will is not a will. Can't tell you how many times people, oh yeah, I have a living will, I'm good. No, a living will is just the pull the plug thing. Okay. That's all that is. It's the end of life, pulling the plug, you're in stage condition. You're not going to make it. It really makes the passing much, or the emergency situation much more, or less traumatic if you have a living will. So everyone out there should have a living will. And many of you also should ask for a DNR next time you're at the doctor. So another episode to look at is my mom broke my hip and now what I believe was the title of it. And a trust. Okay, here we go. Do you need a trust? I'm going to give you an example. Okay, down here we have a grocery store chain called Publix. It's awesome. So here's an example. Publix has cashiers, right? Your little cashier working at Publix. She's living paycheck to paycheck. Based on her employment, she gets life insurance. There's a life insurance policy that Publix will pay out for over $100,000 if something were to happen to that cashier. She has a daughter who has cerebral palsy. Okay. That little cashier living paycheck to paycheck, needs a trust. Because if she died, that life insurance policy is going to pay out to a daughter with cerebral palsy. So what she needs is what we call a testamentary trust. It's just another couple of paragraphs in her will. It's a testamentary trust. It's not a living trust. It's not a living revocable trust. She just needs a simple trust in her will that says, when I die, all my assets are going to be put into a trust for the benefit of my daughter. Okay. Didn't have to do with she's a gazillionaire and needs a trust. Whether you need a trust or not is really not a function of your wealth. Very often it's a function of, is there someone in your life that's going to need care after your death? Is it a spouse that may have dementia? Is it a child with cerebral palsy? Do you have minor children? Do you have a horrible, your son's married to a horrible person and you don't want that daughter-in-law to get it? So you want to protect assets, or there's someone you want to care for after death. Those are the two primary reasons to consider trusts. And again, they don't need to be revocable living trusts. These things can be done in a will in a much more simple and efficient fashion. Now, there are lots of kinds of trusts, just like there are lots of kinds of cars. And some people need the sports car, some people need the minivan. And just like, and some of that is driven by your tax bracket and your wealth. So again, I can't go into a lot of detail about all that because we don't have time, and that's not what I'm here for today. But when you sit down with your estate planning attorney and they start talking about trusts, make sure you understand why you need a trust, not just because everybody else has one and every ad you read says you got to have a trust. That's not why you need a trust. Really think in your own words why you need a trust. Darnell, I'm seeing your thing. Testamentary trust is the same as a special needs trust. It is not. Those are two very different things. A testamentary trust can be a special needs trust, but it doesn't need to be. Testamentary just means it's in the will. You can have all kinds of different trusts in a will. So trusts themselves is like a contract. What is a trust? Trust is a contract that you're entering into with yourself. Okay. It's a piece of paper. It says, hi, this is the Darby Jones Trust. I'm the trustee. And this is what I want to have happen with all the assets that I'm going to put into this trust. First of all, while I'm alive, I want it to take care of me. I can put stuff into the trust and I can take stuff out of the trust. At the end of the day, this is what I want to have happen. But during my lifetime, if anything happens to me, if I start going crazy, or if I'm injured, or I'm unable to handle my affairs, I want Jennifer, my favorite daughter, to be my trustee. So I'm naming a successor. So I've created this contract almost like its own entity, like a corporation, and I'm the president. And I'm going to be president as long as I can be. But if ever I cannot serve as president, I'm naming Jennifer as my successor president. Right? So, and you may have more than Jennifer. You might have Chandra and then Michelle. I have 3 different successors. So if Jennifer is unable or isn't interested in doing it, then it can move to Chandra. So trusts are a living document. They don't have to be. Again, we can have a testamentary trust in your will, but a revocable living trust can be revised, amended, changed throughout your life. Any of these documents can be changed as long as you're competent and over 18. So probate. Probate is our friend, okay? Probate is technically the court supervision of a person's will, okay? Court supervision of a person's will. Imagine a football game without any referees, okay? Or a highway without speed limits, or the boating without the Coast Guard, okay? Administering an estate without probate is kind of like that. It can be kind of the Wild Wild West because there is no court supervision of a trust administration. They only get involved when litigation starts, which sadly happens more often than we like. In fact, in Florida, the trust section of the Florida probate section is the fastest, trust litigation is the fastest area of law, growing area of law in Florida. So probate is not the monster in the closet that everybody seems to want you to think it is. And again, not every estate's the same. I'm being very general here. There are times where trusts are incredibly important and valuable. But for the most part, probate and a will and these documents are all you really need. And the other thing you need to understand is in every single one of these documents, you need to name a fiduciary. But in any case, let's talk about probate. So Chandra, can you pull up our we've got a very sophisticated chart I want us to look at together here. What? I wish I could hear you all laughing because I know somebody's out there laughing. Okay, what is probate? Okay, so everybody on the planet at this moment can own things 3 ways. Okay, that's the only way you can own stuff. You can own stuff in your individual name. That's the person there, own my stuff alone on the left. I think it's on your left. You can own stuff jointly. Okay, and a lot of people who are married, that's where most of your assets are. You own your home jointly, you have a CD jointly, your bank account, your investment account, your car, the second home, your business, whatever it is, you own it jointly. Now, some of you may own jointly with other people, with a business partner or a neighbor or a friend, or you and your daughter have your bank account together, which you shouldn't have. So those are joint assets. Then on the right, you've got this circle with a K in it. K stands for contracts. Okay. Now, 50, 60 years ago, this circle would not be that big. But nowadays, when people have so many assets under contract, this circle is getting bigger and bigger and bigger. This circle means contracts. Remember, trusts are contracts. So trusts, IRAs, insurance, anything that has a beneficiary designation where you have written in it where it goes. Those POD, TOD things, transfer on death, pay on death, you have written where it's going to go. Your IRA has a beneficiary designation, 401k, your annuities, anything that considered a contract. Now, if you all doing a mental inventory right now, you all have a lot of stuff in that circle, right? Well, the only stuff of those 3 circles that's going to go through probate is the one on the left, the stuff that's in just your name alone. Your shoes and socks, maybe your car and your house, or whatever it is in your name alone. That's all that's going to go through probate. Those joint assets go to the joint owner automatically. Whoever it is, it's just going to go automatically, whether it's to your spouse or to your business partner or to the daughter who is on the account, all of that operation by law automatically. The contract assets, of course, are going to go by who you have written on that contract. Is it going to go to my daughter? Is it going to go to my benefit? Who are the beneficiaries? Which is why it's so important to make sure you keep up to date on all those beneficiary designations. So often you have heard that people get divorced, they forget to update the beneficiary on their IRAs or insurance, and here it is going to the ex-wife, which probably isn't what was intended. So you can forget these things sometimes. So when you're going to the estate planning attorney, make sure that these items are very much clear to your mind. Who are the beneficiaries named currently? Because you might have some follow-up homework after your estate planning consultation to clean up those beneficiary designations. So here we are. Your will is really only going to apply to that stuff that's in your name alone. Most of you out there, if you're married, most of your stuff is going to be in that middle bucket. And so at the death of the first spouse, most of your assets are going to go to the surviving spouse automatically. So probably probate isn't going to be that big of a thing, and you're going to end up on that left circle with all the assets in your name, which is another time and a reason, of course, to update your will. But that, I hope, helps you sort of categorize your assets in your head about what is probate and what isn't. Now, if you didn't have a trust, there'd be more assets in your individual category, which is not a bad thing. Your will is going to control that. Okay. Some of those beneficiary designations of these contracts, they could say to my estate. You know, if you're a single individual and you want it to go by what your will says, your beneficiary could just say to my estate. That way your will controls all of those assets. So we're done with that, my sophisticated chart there. And but I hope it just helps you basically kind of understand where your assets are, and going forward, kind of keep that in your mind. Number 6. Whew, got 15 more minutes, guys. Number 6, selecting the right fiduciary. Okay, I've mentioned this before, so we can maybe go through this a little quickly. But again, episode 1, we talk at great detail about who is a fiduciary, how to name a fiduciary. Let's say you're all by yourself. How do you find someone to serve? And there are a lot of individuals out there who are alone. They don't have kids. They don't have a spouse. So who and how do you find someone to serve in these capacities? And I'm going to address that in a minute. But before we get there, when you're naming, let's say Jennifer, I don't see who the husband's name is, but Jennifer and her husband, let's say they're now going to go get their estate planning done. And they have 3 kids, me, Chandra, and Michelle. Okay. And I'm the favorite and I'm the smartest. Okay. So they're going to name me as their power of attorney, and they're going to name me as their healthcare surrogate, and they're going to name me as their personal representative. Then they're going to name either Michelle or Chandra after me. So if I all of a sudden am not the best daughter, or I'm not interested in doing the work, or I die, or I become incapacitated, you've got successors named. The more, the better, because you just never know. You never know. Now, the other thing that I want Jennifer and her husband to do is to talk to me about it. You know, I need to understand what their assets are, and I need to know where they are and how they're titled and what their goals are. So a lot of what they talked about with their estate planning attorney after the fact, they need to talk to their fiduciary so that I understand what their goals are, their fears are. You know, Chandra can be a real pain. So we're going to try to deal with Chandra, and this is what we put in our plan to make sure dealing with Chandra goes easily. So, and you also don't want to name us jointly. Okay. You don't want to have me, Chandra, and Michelle, all 3 co-agents or co-personal representatives, because that means all 3 of us have to agree, and we've never agreed about anything. So how in the world are we going to agree about how to manage you guys during your lifetime if we all have to come to the same decisions, whether it's healthcare surrogate or power of attorney? And that's why I say name the same person in every role. Okay. Let's say Michelle is a nurse. She's got, you know, she's a nurse. She knows all the medical stuff. Well, that might be true, but she also doesn't have time to be a healthcare surrogate. And she's got 4 kids herself, and she lives, you know, in Alaska. So while Michelle may have some medical knowledge, she may not be the right fit to be named as healthcare surrogate. Because if I serve as a healthcare surrogate, I reach out to Michelle and I say, hey, Michelle, mom's in the hospital and they're about to cut off her right arm. What do I do? And she's going to help me come to the right decision. So just because I'm named healthcare surrogate doesn't mean I'm not going to collaborate with everybody in the family that has expertise or ideas or input, but you just need one person driving the car. Okay. You don't need all 3 of us trying to drive it. And I want to drive all the car. I want to be the power of attorney, healthcare surrogate, trustee, and executor, because it makes it just smooth administration if it's the same person. Does that make sense to everybody? So now here, let's talk about how you find someone if you don't have anyone. And this is important because there are a lot of orphaned adults in the world today, especially here in Florida. So you want to make it your job to create a community around you and to find someone that you may be able to name in these important capacities. It might be a friend from church, or start volunteering, get involved with AARP. I mean, they've got a million things going on, and you're going to meet wonderful, like-minded people. So make an effort to meet people, to create that community, to live in a community that is close-knit and has kind of an eye out for the neighbors. Back in the good old days, where we could tell if something was wrong if the newspaper was piling up on the driveway. Well, we don't have that advantage anymore. So it takes a little bit more effort nowadays to create that sense of community and caring among your neighbors or your community or your friends. Book group, church group, whatever it is. You just treat it almost like a job so that you really work at it. And online, you can even create an online community and online friendships. I have a client who she emails with her friend every day. And if they don't hear from each other, then they call. And that's their message. That's the newspapers piling up in the driveway. That's how she knows something's wrong. And you also want to communicate with your fiduciaries about who to call if something's wrong. So if you name your daughter or your son as your fiduciary and they're visiting over Christmas or Thanksgiving or whenever, take them around and introduce them to your hairdresser, to your banker, to your financial advisor, to your neighbors, so that those people know who to call if something were to happen to you. Okay. Have your information handy, have their information handy. So you're leaving breadcrumbs around. So if something were to happen, that fiduciary that you have named is going to get that call. And again, there's a great episode about how to prepare all of this kind of stuff and how to do it. And my mom fell and broke her hip. Now what? So after this, you've got 2 episodes you've got to watch at least. You also want, once your documents are done and you've got your power of attorney, you got your healthcare surrogate, you want to share that document with your doctor, your financial advisor, your insurance advisor, anyone that may get that call from the daughter or the son saying, I need to get access to my mom's account, so that they will have heard about it. They'll have a copy of the document. They're going to be aware, hopefully, that if something were to happen, they've got it hopefully in their file and their records that your son or daughter, whoever you've named, may be calling. So you want to share those documents with those people. Number 7. So what to do with the documents? Where do you keep them? Where do you share them with your family? Do you keep them private? How do you deal with the actual documents themselves? Many attorneys will save the original documents in their own office. I'm not a huge fan of that, because if you really need an original and it's a weekend, that could be a problem. Same thing with a safe deposit box. Those are really not the most convenient location for anything, really. I'm not a big fan of safe. We can talk about it another day, but safe deposit boxes are not easy to deal with. And today, most of what you have in there you can get it now online, whether it's a deed or a car title or a marriage certificate. All that stuff is accessible elsewhere. So you don't really need safe deposit boxes like you did in the past. So if you don't need it, or if you don't even remember what's in it, go empty it out and get rid of it. But anyway, you can keep your originals yourself in a safe place, obviously, fireproof box, whatever, in your home. And I am not a huge fan of sharing my estate plan with everybody, because I may change my mind. I may not want Jennifer to get my annuity anymore. And I don't want Chandra to get my house anymore because she married some idiot. And I don't want, I'm punishing her. Or Michelle, she's the one that's now the rising star, and I want everything to go to her. But now I've just shared my will with everybody, and it's awkward now to just change it. So all I want to do is tell everybody, you know what? I just want everybody to know I have my estate plan done. Everybody should feel comfortable and confident that everything's in order. If you ever need any help, call Mr. Smith, my attorney. He's got everything. Okay, so just let them know that you've got everything in order, things are in place, and they don't need to know the details. Now, that might be a little different with the power of attorney and healthcare surrogate. Again, in those documents, you're not talking about giving stuff away. That's just giving someone authority. So if I've named Chandra as my healthcare surrogate, I want her to know that. And I want her to know who my doctor is, what I'm allergic to, where to take me, where not to take me, that kind of thing. And if Michelle's my power of attorney, I want her to know where my accounts are, who's my banker, who's my lawyer, blah, blah, blah. So that if something were to happen to me, she's armed to be able to take care of things. Number 8, one of my favorite things, tangible personal property. Oh my goodness. I don't know that there's been a single estate that I've ever dealt with that tangible personal property wasn't a problem. Okay, tangible personal property is your stuff. So Jennifer, that bookcase behind you with all that stuff on it, that's tangible personal property. And you probably got a lot of it around. Okay. Oh, it's his fault. Get it. Okay. So that becomes a problem. Okay. For example, there's a will that says, okay, when I die, I want my niece to be able to come and get everything that belongs to my grandmother. Okay. Well, I died and Chandra's my personal representative. How does she know what was my grandmother's? How does anybody know what was my grandmother's? So here's my niece showing up saying, yeah, I want everything. All of this was grandma's, so I get everything. Okay, how does that get resolved? Or it says, I want my personal property to be divided among my beneficiaries and equally. And if any arguments, the personal representative can solve any arguments. Thank you. Well, okay, I've got a grand piano and I have that big bookcase back there. I've got china, I've got cars. How is my estate supposed to pay for all of that to be packed and shipped? Or are they supposed to pay for it to get the piano or the bookcases? So you got to really think through that tangible personal property stuff. My best advice is to give it away now. So, Mr. Jennifer, let go. Okay, you got to let it go. Give it away if you can, obviously, emotionally. Just go ahead and give your niece the pearl necklace, or go ahead and give your daughter the china, or whatever it is. They don't want it anyway, apparently, anymore. But try to give away as much as you can give away now. And in many states, you can have a thing called a separate writing with all the stuff listed on it. Okay. And don't just say the painting over the sofa, because that could be any painting, because you could have moved and the sofa's gone and we don't know what painting you're talking about. So if you do a list, make sure you have hopefully photos or a little better description of what it is. Not my ring. Okay. Because there could be a lot of rings. So try to be as detailed as you can. Number 9, we're almost there. Okay. Number 9. Oh, well, we've covered this too. Don't take advice from financial advisors, banking, or insurance people, please. As tempting as it is, there are too many gimmicks out there. Don't be fooled. Estate planning is still what it used to be 100 years ago. It's really not the shiny objects that they like to distract you with. Number 10, take your time. Okay. Don't call the attorney a week before you're going on your cruise to Europe. And, oh, we need our estate planning done. It happens all the time because now you're thinking about it. Okay. We're going to get on the ship. It's going to sink. We better get our estate planning together. So don't start planning it right before you're going to go on a vacation, because estate plans can take time. You want time to be able to go to the attorney, prepare for the attorney. Now, today, I hope I've armed you with what to be prepared for. And then when the documents are drafted, you got to read them. Okay. I know you hate that part, but you got to read them. And you got to think through some of the real practical issues. Is my daughter really the right choice? You know, it's not an honor to be a power of attorney. It's a lot of work. Did I pick the right one? And you don't want to make these decisions quickly. You want to have it kind of flow over you and absorb it and think about it. So if it takes weeks and weeks, that's okay. There's no pressure. In fact, the more you think about it and the more you seek through it, the better the documents are at the end of the day. Okay. So don't feel like you're in a rush. Ask questions, be comfortable. And when you're done, be happy and relax and know that you've got a solid plan in place. And that's one huge stressor off your shoulders as we all venture into this aging world that we're all going into. We've got 3 minutes left. Of course, we can go over if we need to, but I hate to go over an hour. It seems like a long time. But Chandra, Michelle, are there any questions in there that I need to maybe answer? Hey, Publix employees make good money. That's true, Ralph. That's a very good point.
There were a few questions and you may have addressed them. One of them, Ellen had asked about dower rights.
Dower rights?
I may be saying it wrong.
It might be spousal rights. There are some spousal, every state have statutes that do address a disinherited spouse. So that might be what she's talking about. I would say ask that question in whatever state you're in, because that could be a very important issue. Definitely. Spousal rights.
And someone asked, is separate listing part of the will?
We typically don't put that listing in the will because it can change. You know, again, Chandra pissed me off. I don't want her to have that ring anymore. I don't want to have to go back and redo my will because of that. Very often the will make reference to a separate writing. And then you want to keep that separate writing with your will. Should be an original. You should sign it and date it. And again, be very clear with it. But yeah, you should be able to update those without having to put it in the will. You shouldn't put your funeral plans in the will either. Okay. For, I think, obvious reasons, because so keep your funeral plans separate. That's something your healthcare surrogate should be aware of, what your plans are, or goals are. Cremation, burial, where, that kind of thing. Not a fan of prepaid funerals either. We can talk about that another day. Anything else?
What about irrevocable trusts?
Irrevocable trust. Remember, there are dozens of kinds of trusts. Irrevocable trusts are one of those. That's kind of one of those sports car models. They do achieve a specific goal, and that is more of an asset protection issue or a creditor protection issue. If you don't have that in your world, you don't need an irrevocable trust. They can sometimes come back to bite you because they're very hard to amend as things change. You know, you do your documents today, they may not really be needed for another 10, 20, 30 years. So what you thought made sense today may not make sense 30 years from today. And if it's irrevocable, you may not be able to change some of those provisions.
Does the person have the right to put in and take out of an irrevocable trust?
That is very limited, and it depends on the drafting of that trust and what the purpose of the trust is. And that is a question beyond the scope of this. That's something you would want to talk with your attorney about, and just be very careful. Be careful about joint trusts. Not a fan of joint trusts. Irrevocable trust should be entered into very carefully. So I hope that answers your question.
Thank you.
Is there a booklet or some kind of a written place of your presentations?
Actually, the AARP has an estate planning booklet and I believe it's going to be in the follow-up email, the resource, a link to that. Michelle's shaking her head, yes. And you can go back and listen to this too. I mean, if I've talked too fast and have made no sense, feel free to listen to it again. I understand I talked a little fast, and I apologize for that.
No, excellent presentation. We cannot say anything, but
and you can contact me, you know, Aging Academy.
Yeah.
You can call me, email me. I'm happy to be available as best I can.
slow to grasp, so a written format. So that's fine.
This is patent, you know, I'll let you even have the picture. How's that?
Thank you.
Anything
All
else?
right. I think we're just over time, and I know there are tons of questions, some even in the chat that we didn't get a chance to go to. Just a reminder. Well, first off, thank you, Darby, for joining us once again and providing this
You're welcome.
credible, valuable information that, I mean, every time I hear one of your presentations, I learn something new. And so I do encourage everyone else, if you weren't able to join us before or just need a refresher, all of the episodes since January are recorded and they're on the Aging Academy website. And we're going to be sending out an email to all participants a little bit later today that's going to have wonderful links to resources, including the Professional Fiduciary Council of Florida, for those of you who said, I don't have a power of attorney and I don't have a family member who I can hand it to, and I don't feel comfortable, finding someone online. That's what these great organizations are all about. And so I included in those resources state and national organizations that can help you navigate estate planning, including an estate planning guide that you can download or have a hard copy mailed to you from AARP. And then the Aging Academy site also has Darby's direct contact information. So if we didn't get to answer some of your questions, she loves being able to supply answers. And so go ahead and give her an email and she'll reply to you when she can. Other than that, I did include a link in the chat, and I'm going to also include the link in the upcoming email that will have a calendar of upcoming events. So we've got 2 more sessions on the calendar for 2024, one in August, one in September. Make that 3 because we have one in October as well. So 3 more coming up. We do hope that you will join us.
And keep in mind, I don't mean to interrupt, but next episode is super important. Okay, everybody, it's about dangerous financial decisions. We're going to be talking about reverse mortgages, long-term care, annuities, stuff that you might, get yourself into that may have been a mistake. And I have a presentation very similar to this. That's, I call it my beanie weenie. So you'll love it. Trust me. It's great.
I look forward to hearing the beanie weenie story. Also, in that email that you're going to receive is going to be a survey. And so there's tons of information and questions and things to consider as we're aging. And so we're learning from you. Please do share with us in that survey how we can make these workshops even more informative for you, more engaging for you, and let us know what topics really resonate with you, because that's what essentially drives our agenda going forward. And so we have no lack of substance and content to share with you, but we want to make sure that we're sharing the most relevant information. So do fill out that digital survey and let us know. There is an opportunity for open-ended questions as well. So just share with us what you thought about today's session, but also if you have ideas on content for future sessions. Thank you again, Darby. Thank you all for joining us from all across the country, and we look forward to seeing you again next time.